in person. Welcome to all our esteemed staff members from the universities in Bahrain who are joining us for this virtual webinar. Thank you for joining us. I would like to extend my gratitude to Al-Tamimi company for the fruitful cooperation. Actually, we have long cooperation with them. So thank you very much for Al-Tamimi and for our esteemed speaker today, Mr. Ahmed Saleh, for sharing with us his experience in this topic. And last but not least, I would like to thank the organizing committee, everyone who worked on that from Al-Tamimi Group and from my directorate at the Higher Education Council. So thank you, Jihan, and thanks everyone. This webinar comes within a series of virtual webinars we are conducting starting the second semester of this academic year, and it all works towards enhancing the research capacity building in the universities in Bahrain. So we had several ones with UAE as well. I think a couple of weeks ago with Knowledge E and other ones. So this is a part of a series of webinars that we are organizing at the HEC. Today's webinar, Guiding R&D to Achieve Patentable and Commercially Viable Innovations, is very important topic for us in Bahrain, actually. It is directly connected to the Economic Vision 2030. The 2030 vision for Bahrain states that we need to encourage research and development in universities to create the platform for knowledge-based economy. And a knowledge-based economy requires a research and development which is commercially viable and which can achieve patents. So we thank Ahmed to share his experience with us today regarding this topic. It's really important for us in Bahrain. And we commonly hear from in Bahrain that several researchers struggle in registering their patents. So I hope they come out from this webinar with some tips that would help them. We have the national research strategy that works on capacity building in this term, and this series of webinars is one of the projects we work on at the Higher Education Council. So I would like to leave the floor for Ahmed to start his workshop for today. So the floor is yours, Ahmed.
Thank you very much, Dr. Farzana. Thank you very much for the invite and for this opportunity. Good evening, everyone, ladies and gentlemen. It's our real pleasure and honor to be here today. And as I was mentioning to Dr. Farzana just before the event, the Bahraini are among my favorite in terms of intellectual curiosity, and when I present in Bahrain, I always take into account the double of time I take in any other country because of the very interesting interactions and the questions of the audience. So
we are eager to learn.
Thank you very much. Let me start by introducing myself. So I'm Ahmed Saleh. I'm a partner and head of patents and designs, R&D and innovation at Al-Tamimi and Company law firm. I will share with you my presentation to start with. Okay, so what we will be talking about today is about guiding research and development activities to achieve patentable and commercially viable innovations. So if you can notice from the title itself, we're talking about innovations, we're talking about intellectual property, and we're talking about commercial success. So these three dimensions are extremely important, I believe, and interconnected together. There is a relationship between them. Now, the way I will take this presentation, let me try to move the slide. Okay. the first thing, I am going to introduce quickly our firm. Second, I will speak a little bit about intellectual property in general, and I will not spend a lot of time just on that. But I would like to you all to have a very quick overview on the different types of intellectual property. The second, then I will discuss a little bit about patents, an overview about patents, the importance of patents for universities, the importance of patents for research, and a little bit of overview, the basics of patents. And then I'm going to discuss about how to guide research and development activities to achieve patentable innovations, and not only patentable innovations, but commercially viable innovations. And then I'm going to present you the relationship between innovations, commercial success, and intellectual property, a little bit of statistics around intellectual property and commercial success in the frame of startups and companies. And after these sections, we'll have a questions and answers session, and the entire presentation is scheduled to until, I believe, 6 p.m. Bahraini time. So to start with, Al-Tamimi and Company is a law firm. We have offices across the region. We have offices in Bahrain and in all the GCC countries, in addition to Egypt, Iraq, and Jordan. And we are also opening new offices in North Africa soon. We're about 350 lawyers across the region, with more than 50 nationalities working under one roof. And we're very proud about this, including, of course, Bahraini lawyers working with us. So we're very proud of this diversity, which brings a lot of richness also to our clients when we deliver our services. So if we want to speak about intellectual property, and we look at intellectual property, why did the legislator think about intellectual property? Why does intellectual property exist? Now, everyone, I believe, know the importance of real estate property. Everyone wants to own a house, or everyone knows what is the importance of real estate property, and the importance of not trespassing his real estate property. If you have a house, for example, or a land, you don't want anyone else to cross border and to trespass your property and to jump into your property, right? It's a question of safety, it's a question of privacy, it's a question of securing your asset. So as the legislator thought about the importance of land and of real estate for people, they thought as well of the importance of intellect, or the creativity, the fruits of the creativity, the fruits of the mind for people. If you come up with a new concept or a new idea, which requires creativity, which is original, which is different from whatever exists already, of course, you feel that there is a belonging, a very strong connection between you and that specific creation you came up with. There is a link, a moral or emotional link, and there is also a connection in terms of economics. And if you spend the first aspect is moral, and it's very important. If you come up with an idea or a concept and someone else goes and wants to take the credit for him or herself and taking your concept, you will not be happy about it. Of course. And this is here the legislator came to recognize this very important moral aspect of intellectual assets. And it is protected by the law, as I will explain a little bit later. And the second component is related to the economic side of things. If you spend time and resources and efforts to come up to conceive a new invention, for example, or to come up with a new publication or a new book or a new drawing, regardless what the innovation is, you've spent a lot of time and investments into that. And you would want, of course, to protect this investment. You want to be the only one who benefit from that creation, and to have the exclusivity to monetize over this creation, and you don't want anyone else to to misappropriate this invention and or this concept or this creation, and use it or exploit it commercially without your authorization. So if they do that, for sure, this will harm you from the economic perspective. You will not probably be able to recoup on your investment. So that's where the legislator came in and said, yes, the creations of the mind are as important as the real estate property, and it requires ownership. So we are going to recognize that there are intellect assets, and we're going to give ownership for these. And we're going to legislate to come up with laws to protect intellectual property or intangible assets through intellectual property rights. Intellectual property rights, okay? And so the legislator came with a number of vehicles, okay, to protect these intangible assets. Now, depending on the nature of the intangible asset, then it has to go under the suitable legal vehicle, the intellectual property vehicle, which I will mention here. And we will look how, depending on the nature, you will find a suitable legal vehicle to protect that exact nature of creation. So the legislator came with a number of these legal intellectual property vehicles. The first one is patents, and patents are concerned about inventions. So patents, they are here to protect inventions. So what are inventions? They are technical solutions to technical problems, machine devices, systems, processes, manufacturing processes, for example, chemical compounds, pharmaceutical products. All of these, if they comply with the legal conditions for patents, they are considered to be inventions, and they can be protected through a patent. So a patent is a legal vehicle to protect an invention. Copyright is a legal vehicle to protect a work of author. Copyright, for example, it can work of author. There are a number of categories. You have the literal category, which means the writings, for example, a book, a publication, an article. The content of these are protected by copyright. So it's the expression of this work which is protected through copyright. Drawings, musical works, cinematographic works they all fit under copyright, which is there to protect the expression of these. Software, the source code, the way it's coded as well in itself, it's also protected under copyright. Trademarks are there to protect the source of the branding and the logos which are associated to the source of these services and the products. For example, if you look at commerce, the commerces always have trademarks to represent their services, to refer to their services and their products. Think about Chanel, Gucci, Yves Saint Laurent. If we're speaking about fashion, transportation, the brands of the vehicles, and so on. Altamimi and Company, for example, is also a brand, and it's protected through trademark protection. So industrial designs is another important legal vehicle, which is there to protect the shapes, the ornamental shapes of objects. Think about the furniture, for example. When you have innovative furniture, whether it's internal design, for example, these furniture, these new designs normally are or can be protected under industrial design. It's there to protect the ornamental shapes of things. Even new vehicle, the shapes of new vehicles, it's protected or protectable under industrial designs, and the shape of packages sometimes, and so on. So it needs to be ornamental in nature. Trade secrets are there to protect confidential information. So in your case, for example, when you work on research and you come up and this research, you spend time developing this research, and you have confidential information with respect to this research, as long as you keep it confidential, you keep it secret, you take the measures to keep it secret, it has an economic value. Okay, normally it's protected under the trade secrets law. So trade secrets are important for companies in different fields. You'll find, for example, Google use trade secrets to protect their algorithms, for example, searching algorithms. If you go use the Google search engine, you will not know what is the algorithm behind that. So this is protected through trade secret. Coca-Cola formula is protected through trade secret. They've never disclosed it. They've never applied for a patent, and they kept it secret. They managed to keep it secret all these years. And this is the risk as well they are taking, because if someone comes to the formula independently, without, of course, breaking in the Coca-Cola premises or putting their hand on the formula. So if they come independently and in a legitimate manner to the formula, if they even reverse engineer the product and come to the formula, and they have completely the right to do that, so Coca-Cola would lose their trade secret protection because it becomes public. So trade secret protection loses force, loses power, loses validity when the information becomes public in the public domain. And this is the risk of trade secrets. Is it possible to reverse engineer that specific compound or that specific formula or that specific algorithm? Or it is impossible to reverse engineer it. So this is the balance normally to be done. Patents, however, when you get a patent protection, the information is public, because this is the offset. When the government decides to give you a patent, they give you a patent because you're disclosing your invention, and the disclosure of this invention will help other scientists, other people to improve on it, to develop on it, to know what's the technology, the state of the art, and so on. And this is how the technology and the innovation ecosystem advances as well. So patent publications are among the very important accessible public information for people to know the state of the technology and to learn from the experiences of others, and to come up and to develop to go a step further. And for patents, you'll get a protection over 20 years, of course. And this is what the government will give you as a monopoly. They will tell you, you have 20 years to exploit your invention. Okay, no one else can exploit during that period. And if they want to do so, they have to go and get a license from you. They have to get your authorization. And this is how you would license your patent and get royalties in return, and you start monetizing. So patents are there for 20 years. Trade secret is indefinite as long as it's kept secret and it's not being reverse engineered or discovered by someone else independently and go to the public domain. Okay, plant varieties is there to protect the breeds, the new breeds, and that's an increasingly important sector in the region. And I know it's increasingly important in Bahrain and in the UAE as well. Now Egypt, I think, has a good sector of plant varieties and agriculture, and some other countries in the region. So plant varieties is there to protect the new breeds. There are companies which focus on discovering new breeds of plants, and which, for example, have certain resilience against certain weather, for example, or can grow up in winter or in summer, or so there are discoveries, a lot of research that is done in this area, and innovations which come out of this are protected normally, the breeds, if they are new breeds, through plant varieties. So this is a little bit of overview on intellectual property in general. There are other vehicles like integrated circuits, for example, but these, what I've presented here, are among the most popular and applicable ones in the world of innovation. Here, I will present now an overview about patents. So what are patents? As I mentioned, patents are there to protect your technical solutions to technical problems, meaning your inventions. Okay, so it protects the functional and structural aspects of your invention. If we're talking about a mechanical product, it's protecting the structure, the combination of these components of this mechanical product, right? Or the way it functions. So it protects the functional and structural novel aspects of your invention. And an invention, to be an invention, it has to be novel. And novelty meaning that it shouldn't have been disclosed anywhere else in the world. It shouldn't have been disclosed anywhere in the world before you apply for a patent application. And that's very important. And this is even if the disclosure comes from you. If you're a professor in university and you came up with a new invention and you went on and you published it in an article, okay, you just killed the novelty of your invention. And in most countries of the world, it will be too late for you to be able to go and protect your invention. Now, fortunately, some countries, but few, have given grace period for these inventors to protect, such as the United States and Canada. They've given 12-month period of grace period for you to be able to protect through patent, despite a disclosure you've made within the last 12 months. If the disclosure is more than 12 months, unfortunately, it's too late. There's nothing to be done. That's why it's extremely important that you do not disclose your invention publicly in any manner, neither through an article or through a press release or through verbal communication in an event, for example, before you apply for patent registration. And patents are there once it's granted. It will give you protection to the invention, meaning that you have the exclusivity of exploiting the invention and excluding others from exploiting the invention for a 20 years period. How is this done? For a patent, of course, we need to apply for a patent in front of the patent office in the country where you want to seek protection. And we need to convince the patent office that this is a real invention, that it's novel, that it's inventive, that it respects the patentability conditions, and it's worth to be granted a patent. And in front of the patent office, there's a procedure for that. They will study, they will search, they will look if this is something which is already existing. They have access to many sophisticated databases and hundreds of thousands of publications across the world to see if this invention has been disclosed anywhere else in the world through another patent publication or through a scientific article or in the market and so on. And they will come up with an examination report, and then we will need to defend. And this is how it goes, as we will see a little bit later, until you are granted a patent by the patent office. So what are the benefits of getting a patent? As we mentioned, it's legal protection. So for your invention, without a patent, you have no legal protection, unless it's, you kept the information secret and it's not disclosed to anyone and so on. But if you want to get your product out the market, if it's a product, you want to get it outside to the market, it's difficult to keep it secret, right? So the only way to get protection is to apply for a patent. So the other benefit is that it's a commercialization vehicle. So if you get a patent, it's a legal right. You can license it. It's as if you have a house, for example, and you have your deed of ownership and you want to rent the house. So because you are owner of the house, you can rent it and get a rent, a monthly rent for your house. You can also sell it. Okay, you can do whatever you want with your house. A patent, the same thing. It's a right. It's a legal right. So you can sell the invention, you can sell the patent, you can license it. It means you give the rights to another person to exploit the invention in totality or a part of the invention. And this is a whole different, a big area about what you can license, how you can license. You can license, for example, to another entity a sub group of the rights of a patent. For example, the right to manufacture the invention. You can license without the right of selling, only the right to manufacture. You manufacture. Okay, you can give to another entity the right to sell, the right to, yes, to sell the product, to a part, for example, let's say to Bahrain. You can give another entity the right to sell to another territory, for example, if you have a patent in another territory. So you can decide on how you can license these patent rights to others. And hopefully in the future, we do provide some interesting seminars about the different licensing mechanisms and ways of licensing patents. Hopefully in the future, we'll have the opportunity of presenting this. So the third benefit is business value. Of course, a patent provides a boost in terms of economic value to your company. And that's very, very important. Why? Because why does it give you a business value? Because it's a legal monopoly. If you have a legal monopoly, it means a barrier to competition. It means you're the only one who is having the right to exploit this invention in the market, meaning that you increase your revenues. Increasing your revenues mean increasing your value. So you're keeping yourself distinguished from competition, and you are having the exclusivity of the market for that specific invention, and therefore it increases the value of your company. So if we look, for example, at companies today, if you look where's their value, and mostly if you look at technology-based companies, you'll find that most of their values is in intellectual property assets, meaning patents, the brands, this is where you will find the most of the value. And we have some interesting statistics we'll present at the end of this seminar around that. Of course, here we're speaking about in the commercial context, but patents also have a lot of value and benefits, even in context outside the commercial context. For universities, they have their benefits for ranking, and as we will see, universities count a lot on patents for their ranking, for example, and it's becoming increasingly important for the university rankings. For industry academia collaborations, today universities' role is no longer, as you know very well, only based on education or delivering education to students. It's based on the conducting research. So universities are transforming day after day, and the role of research in universities is increasing day after day, with the research component becoming extremely important to universities. And patents, if they mean something, or they can be used as an index to something, is to the capacity or capability of the university to produce innovative research. So that's very important, and this is something which can attract collaboration for universities, can attract funding for universities, can attract the industry to come and say, can we have collaboration with you? I have this specific problem in the industry in my company, and can I collaborate with your research lab in artificial intelligence and organic chemistry and whatever, to try to get a solution to this problem I'm facing. And this is where the collaboration starts between the industry and the universities. So it's very important. Patents, when you produce patents as a university, you are spreading a very strong message that you are in the core of research, you are leading in terms of research. The more patents you have, the more quality patents you have, the more your message is there about your capability in research, and the more you can attract the industry to come and collaborate in this field, and you can also attract funding, private or public funding, which would come also as a result of your increased capabilities in research. So it will help the university as well to generate revenues. When you collaborate with others, when you license, you come up with patents, you license it out to the industry, you create startups, for example, to go and commercialize these inventions, you are generating revenues to the university and to the inventors who are on board, who have invented. I'm sure that universities have their IP policies with incentives, how to share revenues, how to share the revenues which result from the commercialization of IP. So it is a win-win to everyone. And of course, it has a very important role to building the innovation ecosystem inside the country. Don't forget, universities, the academia is one of the four key the four key players in the market, okay, in any successful innovation ecosystem. So research is extremely important for an innovation ecosystem to run. So you need the research centers and universities, in addition to the entrepreneurial, of course, ecosystems, meaning you need entrepreneurs and startups to be able to collaborate also with universities to take these research ideas and bring them to the market. You need funding through venture capital firms or other types of investments through the government, for example, as well involvement in terms of funding. This is the third key player which is required in innovation ecosystem. And fourth, of course, what you need, the government support in terms of legislations for encouraging innovation, intellectual property. The intellectual property system is very important. The more it's strong, the more it encourages innovation, the more it encourages the development of intellectual property and the advancement of an innovation ecosystem. But the IP system alone is not the only one which can help moving forward an innovation ecosystem. The entire legal system should be should have synergy within it to encourage innovation as well. Where can we find today inventions in universities? I can tell you that you can find it almost everywhere. Okay. Now, the natural places to find it is in scientific faculties, so engineering or sciences, computer engineering, mechanical engineering, electrical engineering, chemical engineering, pharma, healthcare, so in biology, chemistry, in all of these faculties, for sure, whenever there are research going on in these faculties, this is a very fertile environment to creating good research and good inventions coming out from this. But I wouldn't exclude the other faculties, the business faculties, for example. It's not impossible for a business faculty also to come up with inventions. And actually, what we see as a practitioners when we have clients coming to see us from the industry, and people with business background inventing something, uh, they also have normally interesting inventions because they look at things from the business perspective. We have, for example, this product, there is a business challenge, or this product is not really fit for these business needs. And this product needs to be updated to respond to this business need, for example, or this business challenge, and can come up with an idea on how we can adapt this product, for example, for this business need. Now, that person, even if that person doesn't have the technical engineering background and so on, can come up with a concept on how this product can be improved. And this improvement can in itself be considered an invention if it's novel and it's not obvious. Okay, so, and it depends on the products. And as of today, of course, we see a lot of new areas going on. So innovations is not only about deep technology. We see a lot of innovations in mobile applications, for example, in more basic kind of products. If you go to your kitchen and you look at the tools in your kitchen, you'll be surprised how many among these are patented or have been subject to patent protection before. So it can be simple products as well, simple tools as well. Here, this flow chart is an overview of the process the process of seeking patent protection from ideation. So how does it start in the beginning? Once you get your concept, there is a data mining session. Normally, the patent attorney sits down with you to understand your concept and to dig inside the technical the technical invention, all the details around that invention. Now, in many occasions, the inventors come with a preferred way of doing things, or a preferred embodiment, as we call it. So you come up with, for example, a technology, and here our role as patent attorney is to dig around that, to look what are all the variants which can be as well considered for the purpose of patent protection, even if they are less interesting from the commercial perspective. But what we would like really to do here is to help to get the widest scope of protection. We don't want a competition to go and to use a variant of your invention to do the same thing, even if it's a bit less interesting from the commercial perspective. So we want to make sure we capture all these different variants, to also include them inside the patent, to make sure that they are protected as well, to make it more difficult for competition to design around your patent. And in the data mining as well, we will look for your inventive contribution, which is very important. In most of the occasions, you're working in a technology, you're conducting research for a long period of time, and you came up with something, but you don't really know where the real inventive contribution is, which can be somewhere within this technology, can be that diamond which makes your technology an invention. Your technology is a combination of different features, different components, different functionalities, but the inventive contribution, which makes this technology really different and novel and inventive, maybe it's this core, one or two or three things together, okay, which makes it really different. If you don't have this within your technology, you don't have an invention, even if you have everything else. And this is normally what we want to look for, because when we take this core diamond inventive contribution and we protect it, okay, this is your widest scope of protection. Why? Because if anyone takes this core and puts any kind of feature around it, they will be infringing your rights. However, if we go and we protect all the combination of all the features together only, this is a narrow way of doing things. So what we want to ensure is that we get this core inventive concept, and we go and we protect it, and then in the patent, of course, we'll add the combination of all the features together, the variants, and so on and so forth. So once we have this understanding, we go and we conduct a prior art search and patentability opinion to know whether this is something which is novel. And here the search should be focused around this inventive concept, because if you're searching something else, if you're searching features in that technology which are outside this core inventive concept, you're not searching the right thing. So maybe you'll find that, well, this is something which is already existing, and then the report is negative. But you need, this is sometimes the search results are becoming inaccurate, because in the beginning the invention have not been defined accurately. So how you define your invention, the accuracy of this definition of the invention is extremely important for everything else which follows, from prior art search and patentability searches, to the protection of your invention, to the enforcement of your invention, to the commercial application. So it's and so on. So data mining is never to be underestimated. So once we're positive that this, we defined the invention, we conducted the prior art search, or your invention is novel and is inventive in view of the search conducted, then a filing strategy is defined, and then we draft a patent application to cover this concept, and we proceed with the filing. Once it's filed in front of a patent office, and the filing strategy can define in which countries you want this invention to be protected, and where do we start, in which country we start, and fortunately there are time frames which are available under the law to use them to file first in one country to get your priority rights, and then you can have certain period of time before you're required to file in other countries if you want to get protection in more than one country. So once it's filed in front of a patent office, it gets examined by the patent office. Once it's accepted, then it proceeds to grant. Obviously, this examination process, we'll discuss it a little bit more in detail, because this is very important. It takes sometimes the patent office will examine it, will need to make sure that this is novel, will raise objections. And here, this is defending the invention. Our role as patent attorneys there is to defend your invention in front of the patent office. The patent office will try to, will search, and then will come up with examination reports, will come up with objections, will say, well, we've located these publications, these scientific articles, these existing patents, and they seem to disclose the exact same thing of your invention. Or if you put them together, it's obvious to come to your client's invention, and therefore this is not something which is patentable. And then we have to go and defend it and amend try to amend the claims in some occasions, or try to find an agreement with the patent office in order to get a patent at the end of the day. This is a bit of an overview of this process. Once the application is filed, you have a formality phase, because there are certain documents which need to be filed in terms of formality, and then the patent office will look if this are the formalities fulfilled, and then if yes, the patent application will wait its turn until it gets examined as to the substance. Once it gets its turn to get examined, sometimes it takes 1 year, 2 years, or 3 years in some countries before it gets examined. Then here we'll start the examination phase, and what I just mentioned to you in terms of examination reports issued, us answering or responding to these examination reports, and working closely with the inventors for that as well. obviously. And then at the end of the process, either you get an allowance and a grant of the patent, or you get a rejection, and the rejection can be appealed, and the process of appealing differ from one country to another. But what is important to understand here is that your patent application is your foundation. So the process, when we start with the data mining, this is to define well your invention. That's the first very important step in establishing your strong foundation. Then conducting the peer art search is very important to be able to see what's going on around you in terms of, what things exist already, and then it will help you to strengthen better your invention, because in having this site, you'll be able to better as well define and align your invention and maybe work on additional features. And even if your features are already novel and inventive in view of the peer art, then when it comes time to drafting the patent application, we will know exactly how to make it stronger in distinguishing your invention with respect to everything which exists already. Okay, so we'll use this prior art to know what kind of things exist already, and we'll try to distinguish as much as possible inside the patent application to make your invention looks very different and solving problems which were existing before, and it's addressing a solution which hasn't been thought about before. These are general terms which you hear in terms of patent applications. I'll mention them quickly. So you will hear terms like a national patent application, a regional patent application, an international patent application, a provisional patent application, a non-provisional patent application, a continuation application, a continuation in part application, or a divisional application. So all of these terms, you'll hear them, in the legal IP industry. A national application is an application which is filed at the National Patent Office. If you file your patent application in Bahrain, and then at the Bahraini Patent Office, it is a national patent application. And it's distinguished with respect to a regional patent application, which is filed in front of a regional patent office. And there aren't many really regional patent offices. There are currently 5. The European Patent Office, there is the Eurasian Patent Office. There are 2 regional patent offices in Africa, which is ARIPO and OWAPI. And there is the GCC Patent Office. So these are the 5 patent offices, regional patent offices. So when you file a patent application in front of these regional patent offices, we name it a regional patent application. And normally a regional patent application, once it's granted, okay, it leads to the grant of a patent in that region. Now, subject to certain validation steps, it depends now on the laws of that specific region. But for example, in Europe, we'll need to go and validate that patents in the different European countries where you want to have protection. The GCC Patent Office, a GCC patent, once it's granted, it's valid automatically in the entire GCC region. Unfortunately, in the GCC Patent Office ceased accepting new patent applications a couple of months ago, and we're still now waiting for a new law amendments to know how things will be moved forward. International patent application is a patent application which is filed in front of WIPO, which is the World Intellectual Property Organization. An international patent application is also called a PCT application. Why? Because it refers to the Patent Cooperation Treaty. An international patent application, and that's important, an international patent application does not lead to an international patent. There is no such thing as international patent. and I repeat that, there is no such thing as international patent. You cannot file one patent application and have a worldwide protection. That's impossible. An international patent application is a vehicle for you to buy time, okay, before you are required to go and file your application in the countries of interest. And I will explain that. I don't think I've explained that sufficiently in the previous slides. The patent system is a first to file system, meaning patent protection is a question of race. Today, you're conducting research. You are effectively in race against others to come up to inventions. The first one who comes up with an invention, with the invention, and files it in front of a patent office has a priority over the others who come up to the same invention and filing it after this first inventor, this first person, okay? So if I am working on conducting a research in a specific technology or field, and I come up with an invention, okay, and you are conducting research and you're coming up with the same invention. If I go and I file before you, one day before you, I have priority over you. So your patent application will be rejected. Why? Because I came up to this invention. I filed it before you. Okay, it's the first to file. I filed it in front of the patent office before you. Okay, so this gives me the priority. So this first filing, when I take this patent application and I file it in front of the UAE patent office or the Bahrain patent office or the US patent office, it gives me a filing number, the patent application filing number, and it gives me the filing date. And because this is my first application, it will say this filing date is my priority date as well. So if I file my patent application today, which is June 24th, my priority date is June 24th, meaning, okay, if someone comes with the same invention and files it on the 25th of June, his patent application will be rejected. My application has priority over him. Also, this date is very important. Why? Because your invention, when you file it, needs to be novel and inventive. Novel and inventive with respect to what? With respect to anything which existed before the filing date. Okay, so when the patent office will search and to assess whether your patent, your invention is novel and inventive, will look at anything which existed in the public domain, published in the public domain, okay, before the filing date of your patent application. Anything which comes afterward, okay, doesn't concern you, okay, because you came up with your invention before. So whatever comes after you, okay, will not act against you. However, anything which comes before acts against you. So that's why this priority date is very important, the first filing date or the priority date. Okay, so now let's say you filed your priority date in Bahrain, 24th of June, but you're not only interested in Bahrain to get protection, you're interested in the UAE, you're interested in Saudi Arabia, you're interested in Europe, you're interested in the United States, and you're interested in Japan. Okay. Does it mean when you file your patent application in Japan after 6 months, anything which is filed before that time will act against you? How does this play? So for this, there are international conventions that came in place and agreed between the different countries, saying that once you file your first patent application for your invention in any country members of this convention, which is the Paris Convention, most countries of the world. So your patent application in Bahrain filed on the 24th of June, you will have 12 months to file in any other country, okay, all in benefiting from the same priority date. So even if I go and I file in the United States, in Canada, in Japan, in Europe, in UAE and Saudi Arabia on the 23rd of June 2022, one day before the 12-month expiration, the 12-month convention date, okay, it will still be considered as as if I have filed these applications in these countries on the 24th of June for the purpose of establishing or distinguishing myself with respect to the existing art and the novelty and inventiveness and so on. So my priority date will still be considered my first filing date as of the 24th of June 2021. And that's very important. Okay, so the international application, what it came to do, because these 12 months are extremely important and extremely valuable, and companies use it extensively. Why? Because when they first file their first application in one country, okay, they need time before they prepare themselves and they go and they file it in other countries. Sometimes they need to get more money, investments. Sometimes they want to test, to prototype and to test and to get a proof of concept to make sure that this is working, there's a commercial traction for that, and that, you know, before they invest further money to go and file in other countries for many commercial or technical reasons. Sometimes they are improving on that. So for many technical or commercial reasons, patent owners, they have reasons why they want to wait more time before they invest more money to go and file their patent applications in other countries. But they wanted to preserve these rights first in filing their first application in one country. This is where the international patent application came. They said, okay, for these people who want more time, more than 12 months, okay, we're going to give them more time. You have now 2 years and a half from the priority date to file your patent application, okay, in any country in the world member of the PCT convention, okay, which is a lot of countries, most countries of the world. Okay, so instead of 12 months, you just extended this period to 2 years and a half. Okay, and this is therefore when you file an international patent application, you take your patent application, you record it in front of WIPO, you pay the fees between $3,000 and $4,000, okay, for WIPO, and you just bought yourself more time, okay, before you're required and to file in any other country of interest under the PCT convention, all in benefiting to back to your first filing date, the priority date. A provisional application is kind of a temporary application. It's available only in some countries like the United States, for example, and it preserves temporary your rights. You know, when we file a national application, which is it has to have a specific structure and form. You know, we need to work it out. It takes time to work it out. It takes time to data mine with the inventor to make sure everything is complete. For a provisional application, and once it's filed a national application, it will be examined as to the formality, as we mentioned. And this patent application has to have a specific format. If it doesn't, it will be, objected by the patent offices on the format. The drawings, they have to have a specific format in black and white, no shading, no dotted lines, and so on. So there are preparations to be done. And if these formalities are not met, the patent office can come back and can object on these. And the national application, when you file it, to pay for the examination fees, so it costs also more money. So more money, more preparations. So in the United States and some countries, they came up with a vehicle. They said, okay, we recognize some people don't have this time to file because in some agencies, they want to go and publish. For example, professors in universities, they want to go and publish their article. And they call us sometimes one day before they publish. They tell us, tomorrow my article is going to publication and I don't want to lose my novelty. What can I do? Well, we take the article, the content of the article, we put it in a provisional patent application. We don't have time to write a full regular patent application. to file it as a full patent application. So we put it in a provisional application, and we try to add as much as possible to that, and then we file it in front of the patent office. So you're preserving your rights in the content of this provisional application. And we'll have 12 months to go and to convert this into a regular full-fledged patent application. And then we would file it once we convert it. We draft the full regular application. We claim our priority back to this provisional application. So our filing date will be considered to be the provisional filing date. And then we take the process forward. Non-provisional application is a regular application. Continuation in part, and divisionals are kind of, continuation applications, which are divided from the mother application, the first application, for all kinds of legal reasons. I will not dive into detail here. I just wanted to give you an overview of these different terms for you to, I know that it's important. I hear a lot of, misconceptions or misunderstandings around certain terms, like especially international application. It will, and I wanted just to shed the light on these, some important aspects. This is the time frame for PCT applications, which I've explained. So at time zero, okay, you have your local filing application. This is our 24th of June filing date for our Bahraini patent application. Okay, 12 months after, you see 12 months after, okay. Here, this is your convention period under Paris Convention. So you have 12 months to file in any other country member of the Paris Convention. You can decide if you want, so you can decide to file in your countries of interest, Japan, China, UAE, Saudi Arabia, US, Canada, okay, within these 12 months, okay, and so you can do that. However, if you're not ready to do that, okay, for all the reasons we've mentioned before, you can buy more time. And here, if you want to buy more time, we need to file a PCT application before the expiration of the 12 months. Okay, when we file a PCT application, we just bought, okay, yourself another 1.5 years. So in total, it's 2.5 years from time zero. Okay, from 12, if you file your PCT application at the 12th month, minus 1 day, then you bought yourself another 1.5 years from this date, from the PCT filing date. Okay. Okay. So this is what I've discussed so far, is an overview of intellectual property in general. And then the second section was about an overview on patents in specific. And now we're going to discuss a little bit on how to guide your R&D process to achieve patentable and commercially viable innovations. Okay, and that's important. So that's important because when you research something, you want to make sure that at the end of the day, you're achieving something which is novel and new and interesting. So should be patentable. And not only, you can produce something which is new and then it's not useful for the business, or it's not useful for the industry to which it's created. So you want to make sure also that from the commercial perspective, okay, it's viable and it's interesting. And this is the best combination. So that's important to remember. Try from the beginning of the process to think about these two aspects. And I will propose to you a roadmap and guidelines to use, okay, to guide you through this process. Okay, so So let's assume you went on already, you've advanced through your research, and you're conducting your within your research process, and you've already thought on how to approach innovation. Approaching innovation is important as well. I will discuss about it a little bit later, but there are mainly two ways to approaching innovation. One is solution problem approach, and the other one is problem solution approach. So one of the ways is really thinking what the problem and then trying to find a solution to that problem. Okay, and this is, I think, the most popular approach, or the most used approach, and it's the easier to use. And so you look at something which is technical or in a product in the market, and you say, well, what's the problem of that product, why people are complaining about it, and you try to find a solution to make these complaints disappear and to make it more appealable to people, okay, so that people can buy it more. So here you're taking a problem solution approach, and some companies, by the way, are making millions and tons of money about that. One particular company was taking all the feedback, consumer feedback um, from Amazon. So they look after the feedback of consumers on Amazon and on specific range of products. And then they take them on board, and then they try to come to improvements on these products, and they improve these products and they put them to the market, and they made millions and millions of dollars from this. So this is the problem solution approach, which is an important one. So once you adopt this approach, of course, you look at a problem and you try to come to a solution. That traditional way of doing things, and I'm telling you this as I'm engineer myself, and I know the traditional ways of doing this. When I used to spend a lot of time in labs along with my colleagues at École Polytechnique and trying to find solutions to certain things, we used to work most of the time solo. And us as scientists and engineers, we love to work solos and to think about the problems and how we can solve it and so on. And we come up with, very nice, genius technical solutions to these. But in many occasions, these technical solutions, okay, they are genius, but many times they are missing the commercial aspect. And so it's important from the beginning. It's nice from the beginning, I believe, to take a different approach to this, to try to go through a more holistic kind of approach, getting more people, a diverse team involved into that. And this is, I think, where the design thinking process is put in place. And you have very popular institutions like IDEO, for example, which are extremely known in that, and they've learned that process to a lot of institutions across the world, and it's a very famous one. So it's kind of, what is this IDEO process, or this design thinking process? Is simply getting a diverse team looking at a problem from different angles and trying to brainstorm ideas around possible solutions to these, and raining ideas without limitations and without all these obstacles in our mind. And then we'll find ideas coming from an engineer, ideas coming from a business manager, and ideas coming from a marketing manager, ideas coming from a psychologist, and all these ideas, everyone looking at things from different angles and coming with possible ideas. And at the end of the day, at the end of this process, what you'll get is kind of an ideal solution, okay, which look at things from different angles. So instead of having this solo kind of approach and looking at things. It's a kind of diverse team working together to this. And this is also, if you look today, for example, when you come up with an innovation, for example, and you kick off a startup, let's say, and you go and you seek investments. So investors, when they want to assess this startup and assess the innovation and so on, I think these investors are not technical in nature and would really look at innovations from a technical perspective. But what they look at, the first thing they look at, or among the important things they look at, are the teams. They will look at the team, how synergetic is that team together, the diversity of the team, and so on. So it plays an important role. And of course, there are other aspects around the commercial prospects and so on. So if this process from the beginning takes into consideration this, and this is really an invitation to universities to consider that it's kind of building cross-functional teams, okay, and this is, I appreciate very well. It's something different from the traditional way of doing things, of having these the labs, the engineering labs, the chemist labs, and so on, working solo, only engineers, for example, and computer engineers in the computer engineering lab, only electrical engineers in the other one. Is having cross-functional teams working together, even with people outside of the science and engineering sector, coming with more commercial side of things, and brainstorming ideas around certain topics, for example, of research, and possible solutions, and looking at things from a holistic perspective. This is something, I believe it can lead to different results in terms of the way we approach innovation, in terms of the expected results from the innovation process. So, and this is something which you can consider within your universities. Study it, and perhaps you can test it and see how this would achieve maybe different results. So the R&D process needs to lead to achieving something which is novel, inventive, and new, something which is patentable. Ideally, when I get an invention out of this, ideally when I get a patent out of this, you don't want to spend a lot of time, resources, energy, efforts, money, emotions in something, and at the end of the day, you achieve something which is already out there. And why? Because you didn't do the exercise from the beginning of the process to look out there and to look what are the relevant things which already exist in the area of your research, and in the area of your technology. And sometimes you're looking, but you're not looking necessarily in the right places, or in all the important places. Patent publications, for example, are very important to look at, very important to look in these databases. I know because I've been there. I did my master's degree in engineering, and I don't remember at that time I've looked at patent publications when I did my research studies. And so I've looked at the literature, the IEEE publications, and other scientific articles. But patent publications databases are very, very important in that respect. So it's important to have this view from the beginning, to align well the R&D process. In the end of the day, what we want to achieve is patent protection. In parallel, we want also to run to make sure that we're achieving commercial viability, not only patent protection, but commercial viability. And before we go on and we develop a commercial product and we go for the market clearance. So this is quickly about this approach to innovation. I like particularly this section of the presentation because it addresses things from 3 dimensions. from the legal, which we discussed, from the technical and the business together. And I think this is where, if you put these dimensions together, when you approach your research, it will lead you to some interesting results if you keep these in mind. This is a little bit of the design thinking process I discussed before. What you want at the end of the day, and if this is your objective. I appreciate sometimes the objective is completely different than obtaining a commercial product. But if we look at um, um, what you want to achieve at the end of the day from the research, okay, you're conducting, you want to achieve a product which has a market appetite, okay, or a customer appetite. And at the end of the day, your success from the research is is there anyone who is willing to pay for my invention? This is at the end of the day. And this is if you come up with something, and it can be extremely interesting from the technical perspective, but if no one is willing to pay for that product or that outcome, I mean, you should put a question mark. The commercial aspect is missing, and not necessarily commercial if the application process is missing. Okay, even if it's a product which is used for non-commercial purposes, for charity purposes, for healthcare, whatever, but at least the application process there should be an appetite for that, right? If this is missing, then you can have beautiful innovation, but if there's consumers are not willing to pay money for that, I mean, it's missing the purpose. This is how business looks at things. Okay, if we look at things from the patentability perspective, so remember, we need to achieve something which is patentable, and we want to achieve something which is commercially viable and interesting, okay? So from the patentability perspective, from the beginning, it's important to conduct these searches, okay? To look into these publications, patent publications, scientific articles, read through it, and use it to align your concept from the beginning, okay? And don't spend 1 year doing something without looking at these. That's very dangerous, okay? So, and once you come to your initial concept A, okay, then you want to validate, is this something which is novel, is new? Then we would conduct the search, okay, and you'll find that maybe it's already there, maybe someone else thought about the same thing, and still there are issues around that. So this will help you to know what the state of the technology around that concept, who thought about it, why still there are challenges around it, why it hasn't been brought to the market successfully, okay, and then here you can go and you can polish this concept, okay, to concept B, okay, and then you receive, after you continue your research, you come up to concept B. You think now it might be different. You solve the issues or the challenges which been in initial concept A, and then you go again and you validate to do your search. Is this something which is new now? Has someone thought about it? If yes, why they didn't bring it to the market? You look at it and you find out, yes, it already existed, but it's around these features. It wasn't it was too costly to do, or it was the market wasn't ready to absorb it, or whatever reason. And then you go and you refine, you polish it, okay? And then when you refine it, okay, you come up with a refined concept, okay, after another period of research. And here you conduct your search, and then it's novel, okay, it's inventive, and it's a step forward of what already exists. And here, okay, we start to talk about an invention, because you've achieved something which is different, something which is novel in view of what there. And you see here, the approach is not conducting research and waiting to the end of 1 year or 2 years before you achieve something, and then coming to the patent attorney to ask them, is this an invention or not an invention? Here, from the beginning, You are orienting your R&D process, okay, doing iterations in terms of research, of searches, okay, keeping, a view, a holistic view of what's going on there in order to polish your concepts and align and come up with, something which is different. And that's very important for engineers. A lot of times engineers spend time, a lot of time into simulations and in solving technical glitches and things, and they forget the large big picture of achieving something which is different and solving practical existing challenges on the ground. So the more you do these iterations and conduct your searches, the more the patentability chances will increase. Yeah, of course, these prior art searches, what we name prior art searches, are not normally exhaustive in nature. But however, you would want to look at, for example, product which is available, products available on the market, articles, publications, journals, presentations. You want to look at the patent publications, the general knowledge also. Also conducting interviews with people in the industry would help you a lot as well to understand what's going on in that area. Okay, so I will skip this slide. We have more important things to discuss for the purpose of this presentation. So these are examples of databases which you can use. Okay, you don't have to come to a patent attorney every time you want to conduct a search. Hopefully in the future we'll perhaps have the opportunity of providing seminars, training on how you can conduct these searches yourself, at least for the purpose of aligning your R&D process, which will help you a lot. How to read it through a patent publication when you locate it. The terminology is different. It's like reading Chinese in the beginning. How a patent application is written. Is this English? Why does it have to be complicated? And this is because patent attorneys want to protect you more. So there's an art and a science behind how a patent application is drafted, which isn't obvious for everyone who are not used or are new in the process of patents. So we do provide trainings and coaching on how to conduct these searches and how to read it through these patent publications, which will help you a lot into doing these searches and in reading through the results that you locate. But you can take note of Google Patents. It's an open database. It's for free. You can go to Google Patents and you can type. You can search by key terms, and it will give you the results in terms of patent publications which are associated or relevant to these terms. The United States Patent and Trademark Office has a public database. So every patent application which is filed, okay, and for more than 18 months, it's published in this database. So you can access it and you can search in keywords what you're looking for, and it will give you the patent applications which has been filed or registered or granted using or relevant to these keywords that you've entered. SPASNet is the equivalent of the USPTO for Europe. So they have also a free database. WIPO, also you can search the PCT database, so applications which are filed through PCT. And others. So these are free and open for everyone to use them. And there are others which are more professional. It's more through subscription. okay, which firms like, for example, us, we use these to get more comprehensive searches through 92 countries and through hundreds of thousands of publications, searching through all these complex strings of which engineers and scientists love and know, and if not, and all of these things to be able to locate all kind of combinations of terms together to get results. So this is the Google patents here, for example, example of search using stem cells, for example, and it will give you enormous a lot of results, and you can narrow it down using other keywords, and then you can click on these results and open the patent publication and read it through. Okay, so we've mentioned in the beginning of this section the importance of guiding R&D to achieve two important components: patentability and commercial viability. We spoke about how to do that to achieve patentability. So now we will speak on how to do that to achieve commercial viability. So when you came up to your concept, the first thing to do is we need to conduct a market study to find out if this product has commercial appetite. Okay, so if you've been in business before, you know exactly what I mean. If you come up with, your department internally came up with a suggested product, the first thing to do, and that doesn't matter how many hours and how many documents and how many pages they write to convince you that it's the best product in the world. If you haven't been to the market and you haven't asked a potential consumer his feedback about this, it's all useless. Because if the consumer wouldn't want to use it or wouldn't pay money for that, or you didn't onboard the consumer feedback early stages to incorporate it as features in your product, it means that your product has a very high risk of not achieving commercial success. You need basically to get yourself to the market to speak with end consumers, with decision makers, not only with consumers. If you're presenting a product to the education, to universities, something to be used by students and professors, but to be bought by the management, you need to get the view of both the person who's paying money and the person who's using. Okay, so this is the commercial study which you would want to do, okay, in the beginning. So you do your homework in that, and there are specialists in marketing and bringing products to market who can help you in that process. And it's an exercise you can do as well, but be careful when you approach. If you have an initial concept and you believe it's new, don't disclose the product before you make them sign a non-disclosure agreement. And even better, you need to file a provisional patent application beforehand. Don't disclose anything before preferably filing a provisional patent application, and at the least signing a non-disclosure agreement with the people who you're disclosing. Many people will not sign the NDA. And I'm telling you from the practical experience. You go today, for example, and you want to have an entity, private entity or public entity, to sign an NDA for you to explain them about your product. They will tell you, why would we sign the NDA? We will not sign the NDA. So it's much better for you to file for a provisional patent application before. Okay, So once you do that, you go and you validate your product, and then you come up with your minimum viable product. Okay, and this minimum viable product is the first basic normally product you want to put to the market. So you come up with the conception. Okay, the cheapest possible of coming to the MVP is the better. You go, you take the feedback from the market, and then based on the feedback, you need to refine. And this process will go on. Sometimes it goes on for a couple of weeks or months. And it's extremely important. So when you do that and you refine your features and your product based on the feedback, okay, in the same time, you're working on normally in parallel on whether this is inventive as well. And you're working towards something which is innovative and different. So in the same time, you're capturing these both dimensions. You're making sure that it's commercially has this market appetite, okay? And then in the same time, it's something which is novel and patentable. And then you go for a patent protection and for development of your commercial product. Patent protection, we've spoke in length about this. Commercial development, I will not go too much into detail, but as I've mentioned, you need to have your MVP design. You go to have an NDA in place, confidentiality agreement. NDA meaning a non-disclosure agreement. It's the same thing as a confidentiality agreement. Okay, it has its limitations. And if you go and you disclose to someone and that person takes your idea and go put it to the market, the NDA, the only thing you can do is to sue that person. But you will no longer be eligible for patent protection in many countries in the world. So be careful. That's why it's important to file for patent protection before, even through a provisional patent application, which we discussed is a very cost-efficient vehicle to provisionally and temporarily protect your rights. Okay, until you validate what we're discussing here, you know that it's interesting, you want to invest more into it, and then you decide to invest more into converting into a regular application. Okay, so this is a little bit of the process when you have your MVP and your commercial product, okay, and you need to determine what are the countries where you want to commercialize your product. These countries are important for you to decide for patent protection purposes, and not only. Also, you want to look from the regulatory perspectives how your product should look like. If there are any regulatory requirements you need your product to comply to in these different countries. If you are in the telecommunication sector, or your device has kind of receivers and transmitters, so you need to make sure that the ranges of frequencies you're working on are allowed in these different countries where you want to commercialize and so on. Otherwise, you would want to adjust or seek the technical adjustments to have your products also compliant with the different countries. And also, even if when you come to a patent and you have an invention, okay, for your product, it doesn't mean that your product is not incorporating something which may be patented by someone else. Okay, I will repeat that. If you come up to a product, and the product is subject to patent protection because it's something which is novel, meaning that the combination of your features together are novel. In some occasions, okay, and it happens that your product, maybe you're using something, for example, a button or whatever, a device within your navigation system, or any component which you're using it within the product. It's not the essential feature, but it's a feature. And this feature is patented by someone else, okay, in a specific country. So you want to make sure when you go to the market that this feature is not patented and there isn't valid patent protecting it for others in that country. Otherwise, they will sue you for infringement. So this is what we name the freedom to operate search. Is one, you go to a specific country to put your product on the market. So you have now a product. We finished the patent. This is finished. Now we have a product. You want to deploy it to the market. Okay, when you put a product to the market, okay, if this product infringes certain patent rights or IP rights existing there, you're infringing them, even if this product is subject to patent protection for certain features. Okay, so here if you suspect something in your product which may have been patented by someone else as a component, okay, it's important to conduct what we name the freedom to operate search, meaning to make sure that there isn't any patents existing in that country which may cause a risk on the deployment of your product there. Okay, and this is the freedom to operate search. If it's the case, then either we need to design around this, and we do it a lot. We have a lot of the clients come to us and they receive warning letters from other entities because they are using an infringing product, and then we look at it, we help them to design around it. So as we help the clients to protect inventions and to build patents, we're also knowledgeable in knowing how to, if they have weaknesses, patents of others, of course, not of our clients, how to design around it. So the alternative also is to seek a license from these patent owners in case it's difficult or impossible to design around. And this is where the strength of the patents comes in place. The strongest the patent is, the wider the scope of protection is, the more difficult it is to design around a patent. Okay, and if a patent is weak, then it's easy to design around it. And where does the process start? From the beginning, guiding your R&D process from the beginning. From the first beginning, it helps you to go through all this. Your path through you go through is helping you to achieve a strong patent. Okay, because you're polishing step after step. You're validating, polishing, and then as patent attorneys will come and will play this role: the data mining, the putting our hand on the contribution, helping you to guide further if required, and then drafting a good patent application, and then defending it in front of the patent office to ensure the widest scope of protection possible. All of this are all, stones in the foundations, helping you to build this this strong innovation. A very quick window, and we'll complete in 5 minutes. A very quick window on the relationship between intellectual property and commercial success. Is there a relationship between intellectual property, innovation, and commercial success? I know if I were physically in Bahrain today, and if I were physically in front of you to ask this question, I think we would discuss 3 hours about this question together. So the way I see it in the way I'm presenting it in the presentation. And the triangle or the pyramid are among the most stable mathematical shapes, as you know. And these 3 together, okay, if they are in harmony, in good relationship together, they will ensure you get strong innovation and good commercial success, all, when the IP is well protected and looked at it. But let's look at the relationship now. Is every innovation protectable through intellectual property? And the answer is no, because some innovations do not fit within, the legal vehicles we saw in the beginning, the patents, industrial designs, trademarks, copyright, all of this. Some innovations do not fit. There isn't legal vehicle for them, and Some of them, for public policy reasons, they are not protectable by intellectual property. The law doesn't want to protect them for public policy reasons. Business models, for example. Business models are not protectable by intellectual property. You can come to a new concept, for example, cloud kitchen. Okay, I hate cloud kitchens, by the way, because of all the crowd they do in terms of delivery and bikes and so on. But cloud kitchen is a business concept, business model. Is this protectable? The person who thought about the cloud kitchen can protect that to monopolize it so no one else can use this concept or can build a cloud kitchen? No, it's a business model. But if you come up with a mobile application, for example, or you come up with a technology of implementing or working certain processes within this concept, for example, okay, then you can protect that tool or that application. Okay, if you have a certain process, for example, of cooking food, even process of cooking food or preparing food, for example, in a specific way, this is something which can be protected, but a business model in itself cannot be protected. Okay, so innovation is protectable through intellectual property. However, not all innovations are IP are necessarily protectable through intellectual property, right? Because there are certain innovations for public policy reasons are not protectable under IP. Is there a relationship between business success and IP? And the answer is yes, there is. Okay. Is there a relationship between innovation and business success? And the answer is yes. So here, what is the relationship between IP and business success? We will look into some statistics which are nice to look at. So a study conducted by MIT Sloan School of Management found that they've conducted a study on startups, and they found out that a company that have filed for a patent has 87 more chances, okay, to grow and to receive equity growth than a company without a patent. So a patent will help you to achieve commercial success, will increase your chances 87 times. The same study also found that a company which filed for a patent and a trademark and which constituted a company in specific jurisdiction, and in this case, I think it was Delaware, because of the comprehensive IP system they have, which gives insurance, a lot of insurance to investors. A lot of investors in the US to receive venture capital investment, when they look, it's a US company in Delaware, the legal system is comprehensive, the IP legal system is comprehensive, it gives more confidence. And you know how much confidence and trust is important for investors to give money. So it helps, it boosts their chances to 278 times to achieve equity growth. A study conducted by WIPO found that companies with IP have 2 times more business value than companies without IP. And a study conducted on Fortune 500 companies in the US found that IP represents around 65% of the value of these companies. And when we look at from these Fortune 500 companies, those which are tech related, IP represents around 90% of the value of these companies. And it's not surprising to see the last statistic here, 38.2% of the US GDP comes from IP in intensive industries. So this is highlight highlights the importance of IP and the relationship, the direct relationship between IP and commercial success. This brings an end to our discussion, to our presentation, to the presentation, and it brings us to the question and answers session. So we have, I believe, 14 minutes for the questions and answers. Okay. Okay. So if a provisional patent application is filed, is it possible to publish a part of that work? Is that allowed? Yes. Okay. So that's the importance of filing your patent application. Even a provisional patent application will give you that that benefit. Once you file your provisional patent application, you have your priority right. So you can go afterwards and disclose, publish an article, for example, or disclose this invention. It's already secured. So you filed already your provisional patent application. You already have your priority right. Now it's safe for you to go and disclose it. Okay, it's safe to go and disclose it in the sense that it will not play against the patentability of your invention. Okay, it will not play against the patentability of your invention. Okay, now if you file a provisional application, okay, and you go and discuss, for example, your invention with someone for business purposes, and that person goes and steals your invention, we'll name it steal or take it or misappropriate it or whatever, and does something with that, okay, then in this case, okay, now whatever he does with that, you can still go and get a patent protection if whatever you mentioned in your provisional application is novel, inventive, and this proceeds to a patent later on, in converting into regular application, prosecuting it and getting a patent. Once you get a patent, you can go and sue that person, okay? But however, if that person in the beginning, if this provisional application doesn't progress to a patent for whatever reason, okay, you can't do much with that person there. And the way to do that, okay, try, even if you have a provisional application, make him sign an NDA if you can. So the best approach, both, two. One, file your provisional application, and two, have an NDA in place whenever possible. Okay, so whatever you cannot catch under one, you catch it under the second one. Okay, so if he breaches this NDA, if he goes and tries to do something with it without your authorization, you sue that person under the NDA. It's a confidentiality agreement which he breached. I hope this answers the question. Please elaborate on patenting designs and pictures. Okay, so it depends on the nature of the invention. Okay, patent is about the technical technical inventions, technical solutions. Drawings, pictures, pictures. If you mean, for example, taking a picture, this is something which is protected under copyright. Okay, it's not a patent. Okay, designs, it depends on what kind of design you mean. If you mean a design, ornamental design, okay, normally this, if it's related to an object, a product, normally you need to protect this under industrial designs. Okay, if it's related to a product. Okay, So, and if it's original and novel. You can get an industrial design protection. Normally it's 10 years. Okay. And in some countries, the period can vary in some countries, but it's generally 10 years. And it gives you the same benefits of a patent for this ornamental features of your design. Are the requirements different for national and regional applications? The requirements, generally speaking, when we speak about obtaining a patent, uh, there are substantial requirements, which are the main conditions. Your invention needs to be novel, needs to be inventive, and needs to be useful. Novel meaning novel. Absolute novelty is required in most countries of the world. No one else has suggested this invention anywhere in any format, okay, before the application for your patent application, your priority date, okay. Second, it has to be inventive, meaning not obvious for a person skilled in the art, okay. Third, it has to be useful. It means to have a useful utility, a useful application, practical application, tangible results. Now, the first one is a pretty objective. Second one and third one, the way it's applied in the different countries can vary depending on the invention. For example, okay, computer implemented inventions for softwares. If you are in computer engineering, you come up with a software, that process in itself, you go try to get a patent for the computer implemented method of the way the data is being processed. Okay, here, every country, in developed country, they have tests around that. Is this something which is patentable, or is it a business model? Is it technical in nature, or it's abstract in nature? And sometimes when the patent office wants to reject, they reject under inventive, the obviousness condition, sometimes under utility, and so on. So the conditions, novelty, obviousness, and utility, this is, you'll find it in almost any world, any country in the world, and whether it's a national patent application or a regional patent application. But the way the criteria are applied, okay, by the patent offices to look at certain inventions and to assess certain inventions, these differ from one country to another. So when we draft a patent application and we want to file in the United States, okay, related to some areas such as computer processes, for example, okay, we draft it in a certain way to make it fit within the conditions which are, eligible in the United States. If it's to be filed in Europe, we also need to adapt in that respect as well to be able to fit. Some inventions, some patents are accepted in US, are not accepted in Europe. And why? Because these criteria, they can vary in application from one country to another. Okay. So why does the university ranking play a role in patent application? New novel ideas can stem from any institution. Well, as I've mentioned, patents, reflect the research capabilities of an institution, okay, and the capacity to produce innovations. And there is an increasing importance of this for ranking for universities, and obviously the way universities are being ranked take into consideration this, among other things as well. Okay, how can you assist in identifying, evaluating, and protecting potential IP from my research, thesis, research proposal? How will commercializing my IP benefit me, the university, and the society? Okay, identifying your IP from your research is a kind of due diligence we do. It's a technical and legal due diligence. So We'll read through your thesis and we'll identify possible areas of protection, and we'll identify the suitable vehicles to use patent, for example, for certain features or certain concepts under your thesis if they are new and novel and so on. And if your thesis speak, also you've developed something out of your thesis. It's not only a thesis, you've came up with a software or came up with something also. We will look into the protection of that as well, from both the patent side, from the copyright side, and from the trade secret side. There are certain components which are, and we look at it from a comprehensive perspective. And the best protection strategy is the one which take into consideration all of these together. If you file for a patent protection for the entire thing, you will not be reserving any portion as a trade secret protection. If you file something as copyright protection in the beginning, which is very dangerous to do because it means you just disclosed everything. Filing a copyright application with the details of the Copyright Office, it's like you're disclosing them to the public. Why? Because this information is now open for public inspection. Okay, so no longer you can protect through a patent, and you just lost your trade secret protection. So it's very important from the beginning, okay, to have to conduct this technical and legal due diligence, and we look at it. And then we provide you with a strategy on how to protect from how to protect from taking into consideration the different patent, trade secret, copyright, or whatever suitable vehicles are applied. How will commercially my IP benefit me, the university, and the society? Well, IP is, as I mentioned, is your monopoly. Your IP is your you can use it to commercialize. You can use it to ask royalties for your IP when you develop something and you put it to the market. It's your IP helps in keeping the monopoly for this product. So you can monetize your IP, and it helps you in having returns for you, for the university, depending on the on the agreement between you and the society. Of course, if your product or your innovation is constructive for the society, for sure, it will help the society. And advancing innovation and technology, if they are positive and created for the benefit of the state in general, I believe advancement, the technology and innovation in itself is a big contribution to the society. We'll try to take maybe one or two more questions. Okay, for how long does a provisional patent application protect your idea, and can you make it a global region? So once you file your provisional patent application, okay, this is within 12 months, and before the expiration of a 12 month from your provisional patent application filing date, okay, you will need to file, okay, your patent applications, okay, your regular patent applications in the countries of interest, okay, under the Paris Convention. Or if you want to buy more time, more than 12 months, you will need to file an international patent application, or what we call a PCT application. A PCT application will give you 2 years and a half, 30 or 31 months, depending on the countries, from the filing date of your provisional patent application. Before will give you this time, and during this time you can go and file your national patent applications in the different countries of interest. Okay, the last question, I will read it, but I will probably keep it to the audience to think about. It's an open-ended comment. Good afternoon. Thank you for the very interesting and clear discussion. Humanity has come a long way such that we have reached the moon, extended our lifespan, etc. But we could also make our species extinct because of our inventions. Would you kindly comment about the ethics side of it all? Example, cigarette, weapons, manufacturing, cloning, and other possibilities. Thank you. Definitely, and thank you for the comment. I believe that anything we do in this world needs to be for the good. Anything needs to be for the good, and I hope that when you think about bringing innovations to life, also these are dedicated for the good of things. Yes, there is an ethical question behind it. What we want, of course, ideally, we want innovations to be dedicated for the good of the society and for the benefit of the society, and from all perspectives, not only advancing the technology and innovation and getting but also at the end of the day, innovation and technology should be there and to help us to live better and have our better lives and make our lives easier, give us more access to education and to healthcare, make us live longer and in better health. And I think that innovation has played a very constructive role so far in that respect, and hopefully, with people like you, we can influence the direction innovation takes, and hopefully for the best for everyone. Thank you very much all for your attendance. It was an absolute pleasure for me to be here today. I'm very conscious if I were physically in front of you, this would have lasted much more. I look very forward to being with you in the future, and hopefully in the future physically, we'll be with you physically, and we'll have all this pleasure of having interactive discussions together. Thanks again for the Higher Education Council, for Dr. Farzana, for all the universities, all the attendants, for all your time, which you took from just before the weekend. So I think it's really a great and wonderful way of ending our long week and starting our weekend, at least for me. Thank you very much.